Muy bien. Ojalá todos se han ubicado
Okay,
en el
hopefully
cuarto
everyone
adecuado.
is
Bienvenidos, yo
located
soy
in the
Jacob Phelps,
proper
Senior
channel.
Lecturer in
Welcome, I'm Jake
Lancaster
Phelps,
Environment Center in el Reino
Senior
Unido
Lecturer
y
at
director
the
de
Lancaster Environment Center
Conservation-Litigation.org.
in the
Muchas gracias
UK
por
and
su
Director of
interés en este tema.
Conservation-Litigation.org. Thank you for your
Es
interest
un
in this
placer
topic.
tenerlos.
It's a pleasure to have you here.
En realidad, lo sabemos que
We all
no
know
puede haber
that
duda que
there
la
can be
naturaleza
no
está en
doubt that
crisis y
nature is in
que la
crisis
importancia
and that the
de las herramientas
significance
jurídicas
of
para
the
responder a
legal
esta
tools
crisis, bueno,
to respond to this
incrementan día a día.
crisis increase
Y
day by
entre
day.
ellas,
And among
algunas de las
them,
más
some
importantes
of the most
herramientas
important
son las
tools
que
are those
previenen
that
al daño al medio ambiente.
prevent
Pero
damage to
claro,
the
no
environment.
importa
Of
en qué
course,
sector trabajamos,
it
sea de
doesn't matter in what
conservación
sector we
o
work in,
ley o
whether it be
desarrollo,
conservation, law, or
la prioridad
development,
siempre
the
es
priority is
la prevención
always
del daño.
preventing harm.
Pero dada la
But
situación
given the
en la cual nos
situation we
encontramos,
find ourselves in,
no podemos negar la
we cannot
importancia
deny the
de las
importance
herramientas que
of the
responden
tools
al
that
daño que ya ha
respond to the
ocurrido.
damage that has already occurred.
Pero de estas herramientas que
But of these
reaccionan
tools that
al
react
daño,
to damage,
solemos
we
sobredepender de
tend to
instrumentos que
over rely
castigan
on
a
instruments
los
that actually
responsables,
punish those
imponiéndoles
responsible
sanciones,
by imposing
generalmente
sanctions
multas.
and
Y
usually
creo que
fines.
todos tenemos
And
bastante
I
claro
think
que las
we
varias
are all quite clear
limitaciones
that the
que tiene nuestro
several
implementación a través
limitations
del mundo.
in that exist in our
Uno de los
implementations around the
limitantes,
world. But one of the
sorprendentemente menos
limitations,
discutidos,
surprisingly, the one
es
of
que
the
las
least discussed
sanciones,
one,
bueno,
is that
suelen hacer
sanctions
muy
are
poco para la naturaleza en sí
usually
mismos.
doing very little for
¿A qué me
nature
refiero?
itself. And what
Al bosque
do I mean by
destruido,
this?
al
The destroyed
animal
forest,
rescatado del comercio
the
ilegal,
animals rescued from
les da igual
illegal
una multa.
trade, and they
La
get a
especie está en
fine.
peligro de extinción,
Species continue to be
la
endangered.
comunidad que
The
depende del
community that
bosque
depends
todavía sufre,
of the
el
forest still
hábitat sigue
suffers.
degradado.
The habitat is still
Y
degraded.
claro, las
And of
herramientas
course, the
jurídicas que
tools, the
castigan
legal
son
tools that
importantes a la
punish
justicia y a la
are
prevención de
important
daño en
for
el futuro,
justice and
pero
prevention of
son
damage in the future,
incompletas
but they're
en estos casos
incomplete
contextos porque no
in
proveen
these contexts
remedios,
because they
no
don't
ofrecen una
provide
vida
remedy. They don't
lineal para
offer
reparar a la
a
naturaleza.
path to repair nature.
Enfrentados con un medio ambiente
And
que está en
confronted with the
realidad muy
environment,
dañado,
which is
también
truly
necesitamos ver a
damaged,
estas
and we
herramientas
also need to
jurídicas que nos
see
ayudan a
these
reparar
legal tools that
a la
help us
naturaleza
repair nature.
y que verdaderamente ayudan a
And they
responsabilizar a
truly
los que
help
están
us
causando ese daño.
to make those that are
Y ese es nuestro
creating
enfoque
damage
hoy.
responsible. And that is our
Claro,
approach
eso
today, our focus
nos
today.
propone algunas
Of course,
preguntas.
there are
Es
some
que estas
questions that we
herramientas
propose.
jurídicas en
Are
verdad
these
ya
legal
existen.
tools
Si
already
existen, se están
existing?
usando.
If they exist,
¿Cómo
are
los
they being
podríamos usar de una
used?
manera
Or how could
más
we use
estratégica
them more
para mayor impacto?
strategically
Y ese es
for
nuestro enfoque.
more impact? And that is our approach
Estas
today.
son las preguntas que
These
me
are the
impulsaron
questions
a mí y
that
a nuestros
led
colegas a
me
fundar
and my colleagues to
Conservation-Litigation.org.
start with
Nosotros somos un grupo de
conservation-litigation.org. We are
científicos
a
y
group
abogados
of scientists
pequeño
and
pero
lawyers,
bastante
a small
trabajador
one, but we're hard
que
group
estamos
working,
apoyando el
and
litigio
we are
estratégico ambiental
supporting
contra
strategic environmental
organizaciones no
litigation
estatales,
against
tales
non-state
como
actors,
empresas,
such as companies,
individuos, grupos
individuals,
criminales
and
organizados
organized criminal
que
groups
están
that
causando
are
daño al medio ambiente.
harming nature.
Usamos leyes
We use
existentes en
existing
los países
laws
donde
in
se
the
sufre el
countries where
daño
damage is
y
occurring,
priorizando la reparación del
prioritizing
medio
the repair
ambiente
of
sobre
environmental
los
damage
aspectos
over uh,
sancionatorios.
punitive aspects.
Actualmente estamos
We are
trabajando
currently supporting
con varios grupos a través del mundo,
several groups throughout the world,
aportando 14 casos
contributing
en 9
with 14
países.
cases in 9 countries.
Estos casos tratan
And
varios
those
temas,
cases treat
usan
different
vías
topics.
diversas,
They use
estrategias
different
legales
paths,
distintas, pero
different
todas con el mismo
legal
enfoque
strategies, but
estratégico:
all with the same
demostrar cómo las
strategic
leyes
approach, which is
existentes pueden usarse para
demonstrating how
reparar a la
existing laws can be
naturaleza.
used to repair nature.
Y es a eso que nos organizamos hoy, con el
That's
objetivo de
what our goal
proponerles
is
a
today, to
ustedes algunas
propose to you
herramientas, algunas
certain tools and
oportunidades,
opportunities,
varias subutilizadas,
many of them
que existen
underutilized,
específicamente en
that
México y
exist
en Colombia.
specifically in Mexico and Colombia.
Esas ideas que les vamos a
These
presentar
are ideas that are
están
based
basados en nuevos
on
análisis bastante únicos
new
que están
analyses
por
that are
publicar,
very unique.
facultados
They're
por
about to be published,
Natalia y Nora,
provided
y
by Nora
con el
and
fin de
Natalia,
motivar
and this
casos y colaboraciones
to
nuevas.
in order to
Espero que
motivate
podamos
cases and new collaborations.
organizarnos para ver
I
cómo
hope
podemos
that we
trabajar
can
juntos.
organize ourselves to see how we can work together.
A ese fin, me alegro poder introducirles,
And
presentarles
I
4
am happy to be
colegas
able to
que les
introduce
van a
4
platicar hoy.
colleagues that will talk to you today.
Son abogados de
They
México y de
are
Colombia,
attorneys
colegas
from Mexico,
increíbles
from Colombia,
técnicamente,
incredible
increíbles, ¿verdad?
colleagues,
Pero en
technically
realidad
incredible.
lo que me
But in
motiva a mí es que
reality, what
son
motivates
abogados
me is
valientes,
that they are brave
creativos,
attorneys. They're
que están viviendo
creative
la ley
and they're looking at the law from a different perspective. And they are in reality a huge inspiration for myself. This is Natalia Munoz Casolis. She is an attorney, a conservationist. She's Colombian, a legal senior consultant working with us in conservation litigation. Nora Cabrera Velasco, the founder and general director of Nuestro Futuro in Mexico. Dr. Gustavo Adolfo Guerrero, also lawyer and former deputy attorney general for environmental affairs of Colombia. And Anaid Velasco, also lawyer and manager of public policy research in the Mexican Center for Environmental Law. First, Natalia and Nora will briefly present some key results of the analysis that they are working on. Then we will invite Gustavo and Aid to share some of their reactions, and they will respond to our questions. I have a few questions prepared, but I'll invite you, if you have any, please describe them in the chat, and then we will ask you for others. So I'll hand the floor to Natalia now so that she begins to discuss the opportunities that she's seeing in Colombia. Thank you very much.
Lynn, can you please
Thank you,
share
Jacob.
my deck so we can start?
If
Y si no, la comparto yo, pero okay, awesome. Pues como bien lo decía Jacob, y mientras aparece en
As
pantalla,
Jacob
yo
well
les voy a
said, and
hablar
as
de
while
unas
you see it on the
herramientas
screen, I'll talk about the
legales y
tools, the
jurídicas que
legal
tenemos hoy en día en
tools that we
Colombia
have today in Colombia
justamente reparar la naturaleza
to
más allá de una
repair
sanción.
nature beyond a
Y
sanction.
next slide,
And
please. Antes de entrar
before
en
we
los detalles
go
de
into
las
detail
tipologías, las
of the
definiciones, de los
typologies,
conceptos de daño
definitions,
ambiental bajo la
and
ley
what
colombiana,
in environmental
quiero
damage
darles
is
un poco
under
de
Colombian
contexto,
legislation, I
y
want to give you a
es
bit of
sobre la
context.
Constitución
And it is
política,
about
que es
the
la base
political
fundamental
constitution, which is
del
the
ordenamiento legal
key
colombiano.
foundation of the
Tenemos la
legal
Constitución
order
política
in
del año
Colombia. And we
2000
have
en
the political
Colombia,
constitution of
que ha sido
1991 in
llamada la
Colombia, which has
Constitución
been
ecológica.
called the
¿Y por qué?
ecological
¿Por qué se llama
constitution.
la
And why
Constitución
is this?
ecológica y cómo eso permea todo el
And
ordenamiento
how does this
jurídico?
permeate to all
Se
of the
da en
legal
razón de que
ordained? And this
reemplaza
happens
una constitución
because
muy
it
vieja del año
replaces a very old
1886 y esta
constitution from
constitución ecológica
1996.
tiene unos
And this
principios, valores y
constitution,
fundamentos que
and this
tienen
has some
al medio ambiente como su eje central. Y solo
the
para darles
environment
algunos
as the main
ejemplos,
axis. And
en
to
la
give you a
constitución
few
del
examples,
91, el
in the
derecho de
Constitution in
propiedad, de
1991,
dominio,
the
deja
right
de
to
ser un
law and
derecho
domain
absoluto
is
y
no
tiene una
longer an
función
absolute right, and
económica y
it has an
social. Y
ecological,
eso es
social
un principio y valores que
connotation.
irradia
This is
completamente todo
a
nuestro ordenamiento
principle, a
jurídico. Para
value that
darles otros ejemplos,
irradiates in all our
tenemos
legal order.
una
To give you a
gran
few
gama,
examples,
un
we have
abanico muy
a
grande de derechos
huge
colectivos
range
constitucionales
of
que
collective
permean todo el
constitutional
ordenamiento, que dan derechos
rules
a
that
la
permeate the
naturaleza
order
o a
and
los
give
humanos
rights
para
to nature or to
proteger la
human
naturaleza,
beings to
como por ejemplo
protect nature.
el derecho a la
Like, for
participación
example, the right
ambiental,
to
a una
environmental
consulta
participation.
previa
There
a las
is a
comunidades locales, pueblos
consultation
indígenas, cuando
for
se van a hacer
local communities
protecciones
with
de
indigenous people
territorios
when they
que
have
tienen
projects in their territories where
implicaciones sobre
they
el medio
have
ambiente. Teniendo
implications
ese
on the
contexto,
environment.
entremos a
Having
ver qué es
this
el daño ambiental
context,
para
let's
Colombia.
look at
Si
the
bien hay
damage
normas
for
que
Colombia,
describen
the
el daño
environmental
ambiental,
damage. There are
la
rules
prevalencia de
that
la
describe
tipología del
this.
daño ambiental ha sido
The
desarrollada por vía de
prevalence has been
jurisprudencia
developed
y
by
tenemos
the
dos tipos
jurisprudence, and we
principales de
have
daño
two
ambiental.
main
Un daño
types
ambiental
of
puro, que
environmental
es el que se
damage. One
produce
is pure
del
environmental
ecosistema
damage,
como tal, es
which
la
is
pérdida
a direct impact on
intrínseca
the
de la función ecológica del
ecosystem. It
ecosistema.
has an intrinsic
Y también hablamos de un
ejological
daño
loss, and
ambiental
that's what it
puro, por
focuses on.
ejemplo,
And
cuando
we
se
also talk
afectan los
about
derechos
pure
constitucionales
environmental damage when there's
colectivos,
an
como el
impact
derecho a
on
un ambiente
collective
sano.
constitutional rights, like the right to a
Usualmente
healthy
estos
environment.
daños ambientales
Usually,
puros,
this
la idea es
pure environmental damage,
repararlos,
the idea is
destruirlos
to
mediante
repair it,
restituciones en
restitute
natura,
it through
que lo que quiere decir no es más
restoration
que
in natura,
cómo
which
hacemos
means
para
that
resolver la pérdida de la
how
función
do
ecológica,
we
cómo
solve the
regresamos al
loss
medio
of the
ambiente
ecologic
al
function?
estado
How do
anterior
we
al momento que
go
eso
and
ocasiona el
take
daño.
the environment
Por
to the
otra
previous
parte,
state
entonces
before
tenemos
damage
el
was
daño
caused?
ambiental
And on the other
consecutivo,
side,
que es
we
el
have
que se predica de
consecutive
una persona que
environmental
sufre
loss, which
directamente
is
el daño,
happens
bien
when
sea
a
en su
person
persona o en
suffers
su
damage
empresa.
directly. They
Por
think
su
you can think
persona
about
tenemos que lo
themselves
vamos a
as a
ver más
person or
adelante, afectaciones
their
adversas a la salud
property.
por
That can have an
contaminación.
impact on
Y
health
a
for
sus bienes, pues
contamination,
habrá
and
entonces derecho a una
they
reparación
will have a
monetaria
right
por
to a
los daños
monetary
efectivamente
repair
causados
for
o
their
los dejados de
property,
percibir.
and the
Y también
damage
en bajo
to
el daño
money
ambiental
that is not
consecutivo,
gained,
es
etc.
posible
And
obtener reparaciones
it's
por los
possible to
daños
obtain repairs
no
for
patrimoniales, sino
damages that are
monetarios,
not
como
on
el
equity
daño
or not
moral, el daño a la
monetary, like
salud y el daño
moral
a la vida de la
and
persona. Entonces,
health
esto
and
es lo que nos va a
life
dar como una
in
idea
relation.
de qué
This
herramientas
will give
tenemos en
us
Colombia y cómo
the
se aplican.
tools that we
Next,
have in
please.
Colombia and how they're applied. Now, let's see what mechanisms we have to repair nature in Colombia. There are many other paths and alternatives, and with Gustavo, we have looked into this in depth. But today, what we want is to present what we're focusing on, which is what can be promoted by private parties, meaning the civil society, NGOs, individuals, and that can be also fostered by non-state actors. Also, administrative orders, although they don't have a plaintiff, so to speak, from the private sector or NGOs or civil society, if there can be an assistance to environmental authorities fostering those sanctionatory processes. But we have these four paths: constitutional actions, civil, criminal, and administrative orders through sanctioning environmental procedures. And I will explain what each one of these is. Let's talk with the tutela actions. We're going to look in this very quickly. Tutelas are writs of protection for fundamental rights. This tutela, or writ of protection of fundamental rights, it seeks to protect fundamental rights in principle for individuals, but the jurisprudence has advanced and has acknowledged the protection of fundamental rights or constitutional rights that are collective. So although a fundamental right that's individual is right to health or to life, we have also acknowledged collective rights like the right to a healthy environment through these tutela or writs of protection. And what happens when a judge is ruling for one of these writs of protection? They can use any measure necessary to seize the vulneration of the constitutional right that's under threat. And it also has the power of granting measures that reestablish the right that has been affected. They can also rule with measures that prevent damage towards the future as part of this as well. Next, please. Now, what is a public interest action in Colombia called popular? This is focused to the protection of collective constitutional rights. So as I said, the tutela or writ of protection is for individuals in theory, and the popular or public interest one is in group, but there have been some changes. The public interest action then has a preventive nature, avoiding the generation of damage. But when a damage has been caused, the judges, through a public interest action, they have the capacity of requiring restoration. And as I mentioned at the beginning, this can be in natura, which is returning the affected ecosystem to the natural functional state before the damage occurred. When this isn't possible, the judges can grant measures that are in compensation, that can be economic remuneration or the obligation of restoring other ecosystems in other different places as what the damage happened. And also in this type of constitutional action, judges have the faculty to grant measures that go beyond what has been requested by the different parties in the suits. So in the end, what we want is an effective reparation of constitutional rights that have been vulnerable. And last, in sanctions, we have the class action, which seeks to repair the damage that has been suffered by 20 or more people with the violation of their collective constitutional rights. But the difference of this with a nature that is preventive, and it doesn't have any indemnification. They won't pay anyone the money they lost with the environmental damage. The group action has a nature that seeks to repair individual prejudice, moral damage, for example, or loss of profit, for example. There can be measures or order that can avoid the aggravation of this damage in the rulings, but the main purpose is an indemnification. And I'd like to also bring a case to your attention, one that maybe all of you have heard about at some point, because Colombia has been very famous because of its acknowledgement of nature as a subject to rights. But I am bringing the case of the Atrato River. It's in the Colombian Pacific, in the Chocó state, and it has suffered a tremendous environmental degradation with illegal mining. You can see in the pictures, there's images in the picture on the left. You can see, I don't know if you can, these small boxes that are called what they called dragons. They are uh, dragging actually to mine gold illegally, and there is a tremendous contamination with mercury. There is a written protection, which, as I said, should be individual, but it is now into a collective right. And so the river is a subject to right. There is a figure of the guardian of the river that represents the river itself, and the Colombian state is then ordered to restore the degraded areas, the forests, the basins that have been affected, and to protect the biodiversity. Another example of how these constitutional actions can achieve an effective reparation is the case of the ruling you can see here on the screen, where the Ministry of Environment authorized the export of 100,000 kilos of capybara meat, flesh, to Venezuela that represented about 10,000 individuals. The environmental authority had granted a license. In theory, these animals should come from an establishment, but it didn't exist, and the 10,000 individuals came from the natural habitat. They were wild. And in the ruling, it is very valuable because it says that the environmental damage is for a non-threatened species, but eliminating 10,000 individuals from the habitat is a breakage of the balance that is irrational for our natural resources, of course, violating collective constitutional rights. And in this particular case, in addition to other measures, the State Council has ordered that the Colombian state, the Ministry of Environment, mainly to implement measures to repair the population of these capybaras. And there are specific resources set out for this. Then we have civil criminal actions. Civil is when there is damage with non-contractual civil liabilities. In the criminal one, under a crime, the victim at the end of the process has the capacity of requesting that the judge repairs the damages. Although in civil cases, it is indemnification of harm. In the criminal ones, in addition to that indemnification, there can be a restitution in natura, as we had mentioned in our constitutional set out. Next. And last, the administrative orders framed under environmental procedures sanctions. The measures that are for compensation that can be granted by the environmental authorities, the change is confusing because it's not the same to have constitutional compensation measures, but what they seek at the end of the day is to have a restitution in natura, establishing once again the nature and natural resources that have been impacted. Now let's quickly talk about opportunities. I don't know if you all know, but in Latin America, we have this treaty, this environmental treaty, Escazú, where Colombia approved in 2022. And in Colombia, we have many rulings in environmental matters. There are some difficulties still that we believe this can help. So let's say, for example, this reduces the burden of proof. It can be reversed, and there can be access to more evidentiary means in future processes, and that is a huge value we see in accessing to the use of this agreement of Escazú for our procedures in Colombia, where we facilitate the proof of the environmental damage, because there has to be proof, and there are mechanisms that have facilitated and make this proof more flexible, but Escazú's agreement can help with this. Next, please. Another tool that we've identified that can be very useful is the legal ordain in Colombia, because the judicial processes in Colombia take a long time. In Colombia, we have anticipated early termination mechanisms where, in addition to assuming responsibility through environmental damage, those who have caused environmental damage can be
tener que
obligated to
demorarnos 10
repair
años en un
without
proceso judicial.
taking
Entonces
10
es un
years in a
mecanismo
judicial process.
y
So these
eso logró una
mechanisms,
función
although
porque
they
cuando
don't have
se
a
busquen algunas
sanction
oportunidades,
where
sí
they seek
se logra una
opportunities,
reparación
they do
adecuada del
achieve
daño
a
causado.
proper reparation of the
Next.
damage caused.
Y vemos, por
We
ejemplo,
also
en temas
see
constitucionales,
in
particularmente las acciones
constitutional
populares,
actions,
hemos
mostly
visto que hay
the
algunas de
public
estas que están
interest ones, there
subrepresentadas. Digamos que la
are
mayoría de los procesos ambientales
underrepresented, many
han
of them.
estado en
In
torno a la
many of these
protección
cases, they've
ecosistémica,
been
pero por
around the
ejemplo, la
ecosystemic
fauna
protection,
silvestre
but for
en todas las
example,
acciones pues está
wild
representada por
fauna in
1994
all of
2015
the
procesos
public
para la
interest
protección de
actions
fauna
have
silvestre tan
seen
solo
that
representan el
they only represent
1.57%. Entonces tenemos
1.57%.
una
So
oportunidad
we have
de
an opportunity
avanzar con
to
estrategias
advance with
judiciales y de
legal
reparación,
strategies
por ejemplo,
and
para temas de
reparation,
integridad
for
legal,
example,
casos de
for illegal
seguridad o
mining
tipos de vida silvestre en general.
in the
Next.
cases of poaching in general.
Y por último, también haciendo
And
hincapié en que si bien hay
seeing that
muchísimas sentencias en
if there
Colombia,
are
el
many different
principal
rulings in
demandado en
Colombia,
las
the
acciones
main
populares, por ejemplo,
one
constitucionales, es el Estado
in
colombiano y la
constitutional
mayoría de
that
veces
is has been sued is
por
the
default
Colombian state.
creemos que hay que
And
demandar a
by
los
default, many
estados,
times we believe that the
pero
state has to
hay
be
una
sued.
gran
But there
oportunidad para que
is a huge
se hagan
opportunity
estos
so
procesos es
that
contra
these
actores no
procedures happen.
estatales, que son los
This
directamente
is with
responsables de
non-state
ocasionar el
actors, and
daño.
they
Y
are
en
the ones that
medida
are
en que
directly responsible of
lo
causing the
digo
damage.
muchas
And at the
veces,
end of
cuando
the day, and I
demandamos
say
al
this many
Estado
times,
y el
when we
Estado está
sue the
obligado a
state and the
reparar,
state
somos
is obligated to
nosotros
repair,
todos como
it is
contribuyentes con
us
nuestros
as a
impuestos
community
saliendo
with
a
our
reparar el
taxes
daño
that go
ambiental
to
cuando
repair the
generalmente
environmental
alguien
damage
está
when those who
haciendo lo
actually
que
have to
causó.
repair it are the
Entonces,
ones that
el
caused it.
mensaje en
So
Colombia
the message in
clarísimo es,
Colombia
las
is very
vías
clear.
están
The
exploradas, o sea, hay
pathways have been
fundamentos
explored. There
claros
are
presentes
clear
judiciales, hay es que
uh,
expandir
there's a clear
hacia
foundation,
causas que
and we
están
have to
subrepresentadas
expand
y
this
hacia
to
actores no
causes that are
estatales y por
underrepresented and
supuesto hacer
to
muchísimo
non-state
énfasis en
actors.
que
And of
estas
course, we have to
sentencias, estos hitos
stress that these
jurisprudenciales pues tengan una
rulings
adecuada
and
implementación.
milestones in jurisprudence should have a proper termination and representation.
Muchísimas gracias, Natalia.
Thank you very much, Natalia.
Nos movemos directamente
We'll now
a
go
México,
directly
donde
to
Nora nos va a
Mexico,
presentar
where
las
Nora
oportunidades,
will
el contexto y
present
las
the
oportunidades en este
opportunities
país.
and the context
Nora.
in this country. Nora?
Muchísimas gracias. Bueno, pues primero
Thank you very much.
agradecer a
First of all,
Litigation
I'd like to
Conservation por
thank
la
Litigation
oportunidad de
Conservation for
poder
this
hacer un
opportunity
reporte
to
de este
have
tipo
a
en
report
relación
of
con
this
México. Creo que lo que ya
stature
comentaba
regarding Mexico.
Jacob
As
previamente de la
Jacob
necesidad de
mentioned
hablar de qué
before, there's
pasa
a need of
cuando el
talking
daño
about what
existe.
happens when the damage already
Es
exists.
algo muy
It is
importante a
something very,
platicar, a
very important
discutir, a
to
ver cuáles
talk and
son estas
discuss and see
acciones
what
legales
the
que se
legal
pueden
actions are
encontrar
that
para
can be
poder
found to
innovar
be able to
o
innovate
utilizar muchas de las
or use
herramientas que ya
many of the
existen en
tools that
nuestro
already
derecho
exist
mexicano para
in
poderlo
our
llevar
Mexican
a la
law to be
implementación.
able to
Entonces, muchísimas
take it to
gracias,
be implemented. So
Jacob y a
thank you
todo el
very much,
equipo de
Jacob, and the entire
Conservation-Litigation por
conservation
haber
litigation
tenido
team
la
for
iniciativa de
having the
generar
initiative
no
of
solamente este
generating
espacio,
not
sino
only this
todo
space,
un
but
proceso para
an
poder tener
entire
un
process to be
análisis
able to
que nos
have a
permita
proper
tener
analysis that
salidas
allows for us
de
to have
cuáles opciones
outputs
tenemos para seguir teniendo
and
acciones
possibilities of
legales que nos
options to
lleven a la
continue having legal
restauración
actions
de
that
la
take us
naturaleza
to
que en este
restore
contexto
nature,
tanto se
which in
necesita.
this
Entonces,
context is so much needed.
iniciar con eso y agradecer también a todas las personas
And I
que
want to
hoy
begin with
están
that
por
and
aquí
thank everyone
conectadas
who
para
is here
escuchar
connected
estas
to
conclusiones que
listen
les
to
vamos a
these
compartir el día
conclusions
de hoy.
that we
Me
will
voy a
share today.
permitir
I will now
compartir la pantalla.
share
Espero
my
que la
screen.
vean y si por
I
favor no
hope you
la
can
ven,
see
me
it. And
dicen.
if you cannot, let me know.
Híjole, estoy viendo que, a ver. Ay, no, me está pidiendo que me salga de la reunión para poder compartir.
It's actually asking me to leave the
Voy a
meeting to
pasar
share.
el enlace
I'm going
por
to
aquí y mientras
send the
inicio
link here. And while
con la
I start
presentación.
with the presentation,
Bueno, voy a irselas platicando aunque ustedes no la vean porque si no creo que
I'm
llevaríamos
going
un
to talk
poco más de
because
tiempo
otherwise you won't be
en
able to
que
see it.
la
It might take us a
en
long
que la
time
puedan ver.
to
Entonces,
see.
yo se las voy a ir por
Okay,
aquí
so I'm
narrando.
going
Bueno, creo que una pregunta muy importante
to
que
continue talking about
necesitamos
this. An important
seguirnos
question
haciendo
we need to
es quién
follow
repara
is
cuando
Who
¿Quién
repairs
repara la naturaleza cuando se destruye?
nature when it is
Y creo
destroyed?
que esto es una pregunta
I think
importante
this is an
porque
important
al
question
final, como
because
Natalia ya
at
lo
the
comentaba muy
end,
bien al final de sus
since Natalia
conclusiones,
as
el
Natalia
tema de la
mentioned in the
reparación
conclusions,
se ha
the
vuelto
topic
una
of
de las
reparation
preguntas
has
más
become
importantes.
one of
Sabemos que
the
hay
most
daño,
important
¿qué
questions. We know
sucede
that there's
después de que
damage
de
and
que
what
ese daño
happens
ocurre? ¿Cómo se
after
repara?
that
Y también,
occurs.
¿quién repara ese daño?
Who
Y si es
repairs that
reparable
damage
o
and
no es reparable, ¿no?
if it
Porque
can be
esa es una
repaired or not?
siguiente pregunta
And that
que
is a
también ya nos
next
estamos
question that we
enfrentando.
are also
Y yo
facing
les
now.
voy a platicar sobre la
And
evolución de la justicia
I'm going to
ambiental
talk
en
about the
México y
evolution
las
of
nuevas herramientas
environmental
para
justice in
exigir
Mexico
la
and the new tools
reparación del
to
daño.
demand
Y
the
creo que es muy
repair of damage. And I
importante
think
hacer el
it's
contexto de que
also
México tiene
important
una
to see the context that
legislación
Mexico
sólida,
has a
fuerte, bien
solid legislation
articulada
that it's
en
strong,
términos
well
tanto de
articulated in
la
terms of
conceptualización del
the
derecho al
conceptualization
ambiente
of the
sano
right
y
to
el
a
tema
healthy
de
environment and
reparaciones.
the
Tanto en
reparations
nuestra
as well.
Constitución tenemos
And in our
principalmente dos
Constitution, we
artículos que
mainly
son
have two
importantes,
articles that are
que es el
very
artículo
important,
cuarto
which is the
constitucional
Article
que
4 in the
reconoce el
Constitution
derecho
that
al
acknowledges
ambiente
the right
sano
of a
para el libre
healthy environment
desarrollo.
for the free
También hay una
development.
reforma
And there's
constitucional en
also a
ese propio
constitutional
artículo
reform
en
in
donde
that
ya
same
habla
article
de
where it
animales
talks about
como
animals
seres que
as
también deben
beings that
protegerse por
also
parte del
can be
Estado.
protected
Y
by
finalmente tenemos
the
un artículo
state.
27 de la
And the
Constitución
Article
que
27
es
of the
un artículo
Constitution
ya
is an
viejo, no ha
article
sufrido
that is
reforma
old. It hasn't
reciente,
suffered any
pero que
recent
hay una
reform in
interpretación
reality,
muy
but there is a
interesante de la
very
función
interesting
ecológica de la propiedad
interpretation
en
of
términos
the
de los
ecological
límites
conception of
constitucionales que
property,
se
seeing the
establecen
constitutional
para
limits
poder
that are
hacer
established to be able
autorizaciones que
to
vayan en
have
contra de la
authorizations that go
biodiversidad.
against
Y eso es muy
biodiversity.
interesante poder hacer una interpretación de regularidad
And
constitucional, como
this
le
is
llamamos,
also
es
very
decir, el
important to
bloque
have a
constitucional
constitutional
ante la
regularity.
Constitución
So
como
there's a
tratados
constitutional blockage,
internacionales,
and
para
also
poder
or
hablar de
block
si
rather,
bien
also including
nuestra
international treaties, where
Constitución
we
no
see
ha
that
tenido
although
una
our
reforma
constitution
como
has
sí
not
sucede en
had
Colombia,
a
por ejemplo, una
reform as
reforma
we did see
con
in
visión
Colombia, a
ecocéntrica,
reform with an
sí tenemos
ecocentric
elementos
vision, we
suficientes
do
para
have
poder hablar
sufficient
de
elements to
un
be able to talk
basamento
about
constitucional
a
que nos
constitutional
permite
base
tener
that will allow for
interpretaciones
us to have
ecocéntricas y de
ecocentric
reparación
interpretations
muy
of
interesantes. Si nos
very
vamos al
that
siguiente
is very
nivel en
interesting for
términos de
reparation.
legislación en
If we look
México,
at the
tenemos una
legislation
ley
in Mexico, we
específica
have a
para
specific
poder
law
hablar
to be
de
able to
responsabilidad
talk
ambiental.
about
Tenemos la Ley
environmental
Federal de
responsibility. There is
Responsabilidad
the federal law of
Ambiental
responsibility
que ya nos habla
that
y de hecho
talks
habla
about, and in fact, it talks
de la
about
conceptualización de
the
qué es daño
conceptualization
y nos dice
of
que un
what
daño es
the damage
cualquier
is, and the
pérdida,
damage
cambio,
is
deterioro,
the
menoscabo o
loss,
modificación
impairment,
adversa y
or
cuantificable
modification that is
de los
quantifiable
hábitats,
of
ecosistemas,
habitats,
elementos y
ecosystems,
recursos
elements,
naturales,
and
sus
natural
condiciones
resources,
químicas,
the
físicas o
chemical,
biológicas,
physical, or
las
biological
relaciones de
conditions,
interacción
the
entre ellos y
relation
los
of
servicios
interaction
ambientales
between
que
them and
prestan.
environmental
Y
services
nos pone
provided.
ya la
That
definición
gives us a
de a qué nos
definition
referimos
of
con daño
what we're
ambiental y
talking
podemos
about when
ver
we talk
también
about
que esta
environmental
ley
damage. And we
nos
can see
habla
that
de
this
una
law
visión
also talks about
ecocéntrica
an ecocentric vision
de la definición del
of
daño.
the
Y esto es
definition of what
importante
damage is. And
porque
this is
en
important
México,
because
si bien
in
tenemos
Mexico,
una
although
legislación que
we
habla ya de
have
la
a legislation
responsabilidad
that
del daño
speaks of
ambiental,
the
no ha sido una vía
responsibility
tan
of
explorada.
environmental damage,
En
it
México
hasn't been a
tenemos
pathway that has
cuatro
been explored
formas de poder
thoroughly.
introducirnos
In Mexico,
a
we
hablar
have
de
four ways
quién
of
repara la
talking about
naturaleza cuando
who
se
repairs
destruye, ¿no?
nature when
Tenemos
it's
cuatro
destroyed.
formas,
We
cuatro
have
vías
four ways,
procesales.
four
Tenemos
procedural pathways.
vía
We
constitucional,
have the
que es el
one,
juicio
the
de amparo,
constitutional,
que para
which is
nosotros es
the
muy importante
amparo,
el juicio de
which
amparo porque
is
ha significado en el
what is
avance
known as a
en esta
constitutional
materia.
challenge as well,
Tenemos
but
también la vía
amparo law
civil,
is a progress in
tenemos
this
la vía
sense. We
administrativa
have the
y
civil
tenemos la vía
path,
penal.
the
La Ley
administrative path,
Federal
and
de
the criminal one.
Responsabilidad
The federal
Ambiental se
law of
pensó sobre
environmental
todo en la vía
responsibility was thought out
administrativa y
mostly in the
penal.
administrative
Y
and
estas dos
criminal
vías
pathways. And
específicamente,
these
a
two
pesar de que
specific
han
ones,
sido
in
las que
spite of them
tuvieron una
being the
ley
ones
específica
that
de
had a
daño, han sido
specific
las menos
law for
exploradas.
damages,
Y han sido
has been
las
the
menos
least explored. And
exploradas
they have
porque
been
han
the least
sido
explored
las que
because
tienen una
they have been the ones that have a legal consequence that's less clear in terms of the reparation, which would be for practical terms. Although the law allows to go beyond, it's been a legal action path that Mexico has not explored. In terms of strengthening institutions, it's very important. For many years, it was focused on strengthening the judicial power of our federation, and it worked better than a district court through the amparo, reaching the Supreme Court to have a reparation system. It was better to do that than go through the justice, the administrative federal justice, which is a type of power that works different than using the collegiate and Supreme Court appellate courts. It's important to see that if we have substantive legislation that is advanced, we cannot disregard the objective part, the procedural part that allows for us to activate legal procedures is also something that becomes very important to be able to have real consequences in terms of reparation. And in Mexico, what's happened is very interesting, and that's what happened in the report. Both Anaid, who's also here, and myself saw this, and this is a very interesting topic that happens in Mexico in terms of environmental responsibility or in terms of reparation. Many of the legal changes have changed in jurisprudence in different previous cases. And we have cases that we believe are very important to talk about. It's something that has transformed the way in which we can see the options, the current actions we have to talk about damage. And these four are, first of all, legitimate broad interest, which is a very important topic to be able to talk about the access to justice and from then on be able to build a case. I will talk about each of these points a bit more, and I'm going to have a practical example around this. The second is investment of the burden of proof. The term damage there is fundamental. Third, we have the suspension based on the principle of prevention. And the fourth is the restoration above the economic compensation, which is also a key point when we talk about damage and reparation. And this first change around the legitimate broad interest is something based on something very important. The community doesn't have to be the owner to defend nature. And that is something very important that we needed to be able to have clear from the get-go, to have more actions directed to reparation. Because although, as I mentioned before, we have several ecocentric definitions included in our legislation, previously we talked about if there is a matter of damage, it's because I am the owner or I connect to the place where that impact exists. And so we had to see that they had a small property in the place where it was impacted. They were going to request repair for damages of deforestation. So this should be the owner of the location to have this type of legal action. And this is the first thing that changed. If we look at this historically in terms of the precedent, it was very important to be able to go beyond that, to be able to talk about the legitimate interest as something that someone can present, although they have no legal simple interest, but rather an impact for the ecological service. It was one of the main progress we had in Mexico in important cases, which showed this in terms of mangroves at the point. And what we saw is that if a person lives close to the location that is ecologically impacted, there could be a legal action filed against what was going to be damaged or what was already damaged and that was adjacent, so long as that impact could be proven in the ecological service provided by these mangroves in that example. And a very well-known case was the Carpintero Lagoon that reached the Supreme Court, in fact, because of a legitimate interest, where it is resolved by the Supreme Court that those who lived close to those mangroves that were being cut, logged, they could be presented through the Amparo law to repair this ecosystem. And in this ruling, the Supreme Court, in fact, ordered to have a reparation system. It ordered different organizations and the government, but also private entities that had to restore, and the process of restoration was led through compliance by the judicial branch itself. And what we faced in this case was that, as you know, in Mexico, there was a very significant change in the federal judicial power, where all of our judges, from local to federal to ministers of the Supreme Court, are elected by popular vote. And there was a huge legal judicial reform where there was a change of the system of the career that was previously in a system that is now through election. So this compliance has been detained, and we don't have complete information to be able to know in what state it is. But this case was very important because it's a good example to talk about, to look into this reparation system to the judicial power, where it can take this for compliance. Second, we have the change of the proof or evidence is not only on the victim, and that's very important on those that are demanding action. And the reversal of the burden of proof for those who contaminate are the ones that have the best way of showing that there was a diligent action there. This is a very important element because for purposes of damage, not everything falls on the anti-action to demonstrate damage, but also we have this part where the company or the authority can demonstrate that they acted digitally. I know I am over time, but I'm going to go quickly for the very little time that I have left. The other point that is very important is, I have the title in the presentation, nature doesn't repair only with checks. And it's important to see this in this way because at the end, economic compensation is a small compensation. When we talk about ecological compensation, and mostly the federal law prioritizes the recovery of ecosystems, and it doesn't only talk about paying with fines. And I always remember, before founding our future, I worked with large firms, litigation firms, and something that always came to my attention was that many companies said, okay, how much the fine will be, because we'll pay it. And so they only calculated how much it was going to be. So it's going to be this much? Okay, that's fine. Then let's pay. We got the fine. I know what I can do. So, and I felt something that drove me a little bit crazy, because what was that money going to be used for? Nothing. And it was important. I'm not saying that this happens for everyone. Some companies do work properly. Many don't. But so how will it cost to contaminate this river? We don't know, so we'll pay for it. So this is something where we need to insist, because restoring is something very different
Y eso
from
necesitamos
paying.
quitarlo así del chip
And
de lo que significa
we need to
el término
shift our
de
thought
reparación.
of
Creo que
what
lo
the
necesitamos
term
llevar
of
al
reparation
siguiente
actually
extremo,
means. And we need to
que es
go to
en
the
donde
other
la ciencia
extreme,
ya nos
which
está
is where
probando
science
este
is
tema de
already
límites
proving
planetarios,
with these
que lo que
planet limits
pensábamos que todo
that
era
what we thought
restaurable no lo
everything
es.
was restored, could be restored,
Que hay
is not.
cosas que siempre que pensábamos, sí, claro, vamos
That
a
is not
encontrar,
true.
bueno, hoy sabemos que los
Okay, we
ríos
also know that rivers
per se no se
per
restauran
se
así
are
en
not
10 años,
restored
¿no? Que
just like that in
necesitan
10
todo un
years,
proceso,
that
no es
they
nada más
need
meter
a
maquinaria
process
y que
and
al
having
fin ya va a estar
machinery
todo saneado, o sea, no es
where
cierto, no
everything will
funciona
be
así la lógica.
repaired.
Y
And
creo
that
que es
is
muy
not how logic
importante
works. And I think it's very
insistir en esta
important
visión ecocéntrica
to insist in
la
this
argumentación
ecocentric vision
y
of the
de
arguments and also
y del
of
establecimiento de los casos
the
para poder
establishment of
darnos
cases to be
cuenta
able
que
to
la
realize
naturaleza es
that
algo que
nature
necesitamos
is something that
conservar
we
como
need to
está en muchas
preserve
ocasiones
in
y que el
its
proceso de
current status
restauración
in many
no
occasions.
es
And
solo
the
dinero
restoration process
y que
is
sí
not
hay que
only about money,
cobrarle a quien
and that we do
contamina,
have to
pero el
charge
costo
those
no es
who
el de una
contaminate, but
multa,
the cost is
sino es
not
el
a
costo de
fine.
una
It's the
restauración
cost of a
integral.
restoration,
Y
a
que
comprehensive,
el
complete,
siguiente
full
punto, y ahí voy
restoration.
hacia,
And the next
hacia
point, and I'm going
oportunidades,
towards
le voy a
the
ir ya porque si
opportunities, I'm going
no,
to go there
Jacob me
because
va a
otherwise
regañar porque nos
Jacob is going
advirtió que
to
el tiempo era el
scold me
tiempo,
because he told us time
pero
was tight.
en el tema de estas
In
oportunidades,
these
creo que algo que sí
opportunities,
es muy
I think
importante
that something that's
insistir.
very important and we should insist
Yo
on,
personalmente y desde
I
nuestro
personally
futuro hemos
speaking, and
pensado
from our
mucho
future,
en cómo
we've
prevenir
thought
el daño,
about
¿no?
how to
Cómo
prevent
prevenir
damage. Okay,
los
so
casos, pero mientras
how to
hacíamos
prevent
este
cases. But
reporte,
while we did this
la
report,
verdad es que hubo algo que a
in
mí
all
sí me
honesty,
movió
something
muchísimo,
happened that moved me
de
tremendously.
pensar
And it was
que los
thinking
primeros
that
esfuerzos
the first efforts,
ambientales, ecológicos que
environmental
hubieron
efforts
en
and
el país
ecologic efforts that
fueron
we had in the
pensados
country
en
were thought
la
out
reparación del
in
daño
the
y se
repair
hicieron
of
muchos
damage.
esfuerzos
And
para
there were
tener
many
buenas
efforts
leyes
to have
y
good
herramientas para
laws and
poder tener
tools to be able
restauración.
to have restoration.
Y no
And
hemos, y lo
we
digo
have
como una
not, and I
crítica
say this as a
constructiva
criticism,
al
constructive
gremio en
criticism
México que hemos
for the
litigado este
guild in
tipo de casos,
Mexico.
no
We have
nos hemos
litigated all of these cases.
concentrado en
We
las reparaciones porque
focused
creo que nos ha parecido que es
properly
demasiado
because we
complejo,
believe it's very
que es
complex
algo que es difícil, que
and
vamos
it's
a
something
probar el
difficult
daño y
that
que
we're
cómo
going
vamos a
to,
probarlo, pero
how we're going to
creo que
prove
viendo esta
damage,
historia
etc.
de cómo
And I
sí
believe
existen
seeing that
leyes y cómo
how
sí
there can
existen
be
precedentes y
laws
cómo se han
and precedents and
revolucionado
how
ciertos
there has been a
principios como el de la
revolution of
carga de
certain
la
principles
prueba,
like the burden of proof.
y el de la carga de la prueba me parece muy
I
importante,
think
pero
that one
también
is very
pensar en la
important, but also
restauración
thinking
integral.
about
Creo que sí nos lleva
comprehensive
a
full
intentar
restoration,
esos
that
casos,
helps us
porque es
try out these
importante
cases
también
because it's also
visibilizar en el
important
litigio
to
estratégico
see in
cómo es
strategic
lo que
litigation
no debemos de
how
hacer, cómo es
what we should not
ese
do,
daño que
how
existe y
that
que no
damage that
podemos
exists
permitir que
is,
otra
and what
empresa
we
solo haga
cannot allow
números
another
y
company to have
tenga
numbers
el dinero ahí
and have
guardado
the
para
money
pagar su
there
multa.
saved to
Creo que
pay
eso lo
their fines. I
necesitamos
think we
visibilizar
need
más,
to make that
porque
more
también
visible
necesitamos
because we
visibilizar lo que
also need
Natalia
to
decía
make
también
what
al final de la
Natalia said more
conclusión del
visible, what
reporte de
she said
Colombia,
at the end of the Colombian
que no
report.
todo lo puede pagar el Estado,
Not everything can
que
be
la
paid by the state.
restauración,
That
sobre todo cuando el
restoration,
impacto
mostly when
viene
the impact
de
comes
obligaciones
from
o responsabilidades corporativas, tiene
corporate
que haber quien
responsibility,
pague eso y
there
sí
has to
hay
be
quien lo
someone to
paga
pay for that. And
si
there
hacemos los
and there
esfuerzos
is
para
someone to
poder
pay if
probar
we
esa
make the
parte.
proper efforts
Entonces,
to
yo me
prove that. So
quedaría hasta
I
aquí
will
con la
stay until
reflexión,
this point with the idea
la pregunta de
and the
ya no
question
es únicamente quién
of
causó
it's
el
not
daño,
only
sino la
who
pregunta
caused
es quién
damage, but the
tiene la
question is
obligación de restaurar
who
la
has the
naturaleza
obligation of
y cómo las
restoring
acciones
nature
jurídicas
and
nos pueden
how
llevar
legal
hacia
actions
allá.
can take
Muchísimas
us
gracias.
towards that path. Thank you very much.
Muchas gracias, Natalia y Nora, por las presentaciones. Y uno de los colegas ya ha preguntado en el
Thank you,
chat
Natalia and Nora, for the
cómo
presentation.
pueden
Some
acceder
colleagues have
a los
asked in the
reportes
chat, how
nuevos.
can they
Nosotros
access these
quedamos
new
con el
reports?
compromiso que se los vamos a
We
mandar
have the
dentro de un par de
commitment that
semanas
we are going to
por
be
correo a todos los que
sending
han
this
estado
via email in a
participando hoy.
couple of weeks
Y esos
for those
reportes
of
ya
you who are
entran en los
participating today. And
detalles
those
de no
reports
solamente las
are in the
oportunidades,
details, not
pero
only in the
cómo
opportunities, but also how
cómo usar
to
estas
use
leyes existentes.
these existing laws.
Nos movemos ahora
We will go now, inviting you, Gustavo, to share your reactions to the presentations and also responding to some of my questions, but also yours. If you have questions, you can put them in the chat. I am going to start with some questions. Up until now, and as Natalia was telling us, in Colombia, most of the litigations and seen in different countries, that it is usually against the government. How do you see the potential of expanding litigation against these non-state actors, corporations, individuals, organized crime? Anaid, can I hand the floor to you first? Thank you. Yes, thank you, and good morning, everyone. Thank you for inviting me here. Gustavo, Natalia, I knew you before, Nora, but all of you who are connected in this global event pre the World Cup. It's very important for us in Latin America, so it's great to see all of you connected here. Of course, we can look at this part in Mexico. There is a huge potential to expand this litigation against these non-state actors, and more than the potential, I'd like to transfer this to an approach of a need. There is a need of passing this, as Nora said, and also extending these contentious strategies towards the non-state actors. One of the reasons why the litigation is mostly focused on the state is because our legal systems are based on a constitutional mandate that is very clear on a human rights approach. And traditionally, we tend to think, and it's not only a trend, it's a doctrine, and the jurisprudence has mentioned this and stated it in such a way. We have to see who are the stakeholders that are responsible for meeting this. So first of all, authorities, and this gives us a response of how historically we have had this use in the case of Mexico of this amparo law and judgment. I'm going to differ from Nora because I recognize this work of organizations like the one that Nora leads. Amparo creates a huge potential so that from the state, whether it be acts or omissions, that is pulled towards other stakeholders to repair them. In that context, for example, in the jurisprudence line of the court, they've acknowledged that although the authorities are the first responsible of promoting, guaranteeing human rights, in this case, human rights for a healthy environment, which is what we see directly involved when we talk about environment and reparation. And we've seen that the stakeholders have an important role and with responsibility in the protection of the environment. So our amparo law, which regulates all of these aspects that Nora was mentioning, for example, it enables and has the possibility of imposing private actors into these amparo cases, as long as they have functions that are comparable to an authority, and it should be already drafted within a law. So we can have amparo law judgments in private actors. We haven't had the case yet, to be honest. That's a reality. We only have had public actions, but legally speaking, it persists. So that potential is important to acknowledge from amparo, but we have other types of responsibilities, for example, the environmental, administrative, civil, criminal, where this directly can focus a contentious relationship against these actors and demand repair. The environmental law. It has been magnified when we integrate tools, as Natalia mentioned, like the agreement of Escazú, where in the case of Mexico, it's been used for this reversion of the burden of proof, which is not a minor matter. When you have a judgment not against the state, but against a company,
jurídicamente es de igual a igual, pero fácticamente está desequilibrada.
it is imbalanced in terms of the
Son
facts.
las comunidades, ¿no?, que interponen estos juicios o las organizaciones o una.
And we have organizations or the individuals here in the organizations, those who are in a disadvantage before a factic power that is larger, which is usually private actors. And even more so when we talk about organized crime, for example, there is another conversation that we cannot ignore, but can also generate a lot of I should say maybe reluctance when we think about reparation in a sense. The use of the agreement, the Escazú agreement, not only enhances the active legitimacy, but to reverse the burden of proof and also see maybe certain assumptions. For example, you can assume the causal connection, which can be and also an important issue. So prove that your action or omission is directly the cause of the damage. So that line that goes from A to B, that we call the cause annex, is usually a challenge from science. And the court has highlighted in terms of environmental liability or responsibility, we could assume this under certain considerations. If there are no maximum limits where I'm taken out of or disregarded in terms of certain standards, then there is an assumption in favor of the environment. I think that potential exists. There is a need, and we see more degradation of ecosystems in the jurisprudence. And there are some challenges that Nora highlighted. And I think this report is visible to see this potential, to say, okay, there is this range of possibilities. Let's use it as a chess game to see how we'll do at the end of the day to favor nature and those who live in it.
Muchísimas gracias, Anaid.
Thank you very much, Anaid. Gustavo, opportunities for litigation against non-state actors?
¿Cómo lo mira de la perspectiva de Colombia?
How can you see it from the Colombian perspective?
Muchas gracias, Anaid. Un gusto conocerte y saludarte y, por supuesto,
Thank you, and Anaida. It's wonderful to say hello to you and meet you. All of the attendees, Nora, also thank you for such a complete report from Mexico. Of course, Natalia, with who I had the chance to talk because of the construction of that report in the Colombian case. I believe that the opportunities are all, we have them all. And the problem in Colombia has been that many times we think about having results that are quick, very quick. In Colombia, Colombia is known for a justice which is somewhat slow. Ordinary justice is relatively slow. And we've seen in the tutela or the writ of protection and the amparo action in Mexico, there is a remedy, so to speak, for everything from the legal standpoint, and even for matters that, in terms of procedure and nature of actions themselves, should not be solved by a path which is exceptional and very special and subsidiary, actually, in fact. And in that sense, in Colombia, what's common is to use figures, as Natalia explained in detail, like the acknowledgement of nature as a subject to rights. So with that, Colombia has sought out certain effectiveness that has not been reached yet. And I know this, in fact, by my own experience. I had the possibility of following up a delegated controller led by the ministry in Colombia in environmental matters. and following several of these rulings, and there's a common element, and it's the absence of effectiveness, to be honest, in these rulings. Whereas if we go to other procedural means, other procedural actions that Colombia established, designed specifically to seek the protection of the environment as a collective interest, then we find actions that have a very different dynamic and much more effective with a different level. And we've seen the case of Colombia of the Bogota River. This hearing has been leading the fate of what decontamination should be of one of the bodies of water of Colombia that is most polluted, and maybe even in the continent. And what's interesting here is that in that public interest action, every public and private actor was involved, and amongst the private ones, all of those who contaminate the river, the Bogota River. The same thing happened with a public interest action in defense of a bay that has a big issue, and many of you might know it. We all know and love this place, Cartagena de Indias, and the Cartagena de Indias Bay has issues with contamination that are very sensitive and significant, to a point where there was the activity between legal communities, and it should happen with the fishing activities, and that's where private actors also got involved. The point that I have here is that sometimes, on occasion, we believe that in Colombia there is the paradigm that the responsibility and guarantee of having a healthy environment should be led by the state, but it is not that much. There are the democratic model that Colombia built in 1991 is the model of a democracy that is participative, based on a social rule of law and in a principle of solidarity. And that principle of solidarity led us to have different obligations. Each right has an obligation. So it was a shared obligation of the state and the individuals. But we always intend the state to be the one to repair or start the actions to produce that reparation. And it is the mandate of the constitutional Article 80 to look into repair and avoid damage to the environment. So the state has a responsibility not of repairing, but of demanding reparation. And in Colombia, I think we share the same difficulty. The evidentiary matters, the standard of evidence. I read a ruling from April 27 from our state council where it says that the contamination is one thing and damage is another, and damage requires to be proven. It could be, we could have generated contamination, but if there is no proof of the damage, then there can be no reparation ordered. At the same time, there's a ruling from the Constitutional Court, which is tremendously interesting, from 2020. In Colombia, we have what we know as unification in jurisprudence that unifies the interpretation of the constitutional provisions, and this helps for all judges. And a ruling which is 455 from 2020 is very interesting because it establishes new standards of attribution and burden of proof in terms of responsibility with environmental damage. And there's an interesting rule. It says the judge cannot derive an assumption in favor of the contaminating agent by virtue of which the uncertainty on the magnitude and the effect of damage and difficulty of demonstrating consequences, this agent should be exonerated from responsibility. So that is a principle, and that would be a rule that would go against the spirit and constitutional mandate. it is close to a theory of the known theory of civil guilt, where there is we do not look into the cause, the factic cause, and this because there are accusations that are civil. And this was mentioned by Anaid a while ago, where if I have a diligence burden and I do not meet it, then the cause ends up being accredited. And we go to the principle of caution, which we are all very concerned with, mostly because in Colombia, we have tried to see that the legal and public decisions are made with the best knowledge available, because it ends up being in some way an attribution that could be somewhat arbitrary. If we look into the principle of caution, always when there is no minimum exercise of due diligence to reach a proper level of minimum knowledge to make any decision. And then we also have civil actions. Civil actions are not that much into the media, but there are precedents where there has been reparation, mostly in the consecutive damage that Natalia mentioned. I know cases where, for example, given the damage produced in a natural forest, have been obtained we have obtained reparations in favor of the owner. But here with the restriction that Anaid mentioned, because these are civil actions, so we have to credit the legal interest, and therefore it cannot be repaired as a collective in general terms. But I believe that in Colombia, we have evolved in a very interesting way. And I saw a question on the Escazú Agreement, and the Escazú Agreement has been improved very recently and ratified by law in Colombia since 2023 or 2024, if I'm not mistaken. But what has happened mostly on the different control bodies from the ministry has been an exercise to establish the standards. How do we translate this to guarantee access to justice in environmental matters? Thank you, Gustavo. Let's take this of the Escazú Agreement a bit more in depth. Of course, there are several elements, but in particular, this element of the reduction or investment of the burden of proof. What are the opportunities? That element has not been implemented in Colombia, or are there cases? And which would be the actions that we'd have to take to advance in that element of the agreement? Colombia has a paradox, and even before the entry into force of the Escazú Agreement, Colombia is a country that had a good part of the tools and mechanisms that ensured compliance of several of the standards that the Escazú Agreement specifies in terms of access to information and participation. Where we might be more weak is in the access to environmental justice. But that does not exclude the fact that it's necessary to apply the Escazú Agreement in our everyday exercise of judicial rulings. I've seen decisions in both ways. One decision that invokes the Escazú Agreement, it invokes it, but in a very generic, ethereal, conceptual way, if I may, and others that are decisions that are more in the State Council, where there is a decision where they highlight that they require a regulatory development to be invoked and enforced directly. So these are not direct application provisions. In the Office of the Attorney General, we alleged something in contrary. Understanding the Escazú Agreement as a treaty based on human rights, in the sense that we want a healthy environment and in healthy conditions, that in itself is a human right. In Colombia, we apply what we know as the constitutionality block, and these treaties are part of the fundamental rights in the political constitution. And in that sense, it would be of direct application. So we're in this process
instrucción y sobre todo
of
de pedagogía
construction
ciudadana
and pedagogy
para
for our
entender un poco hasta
citizens
dónde y
to
a qué nos
understand
conduce y
what
con qué
this
nuevas
takes us to
herramientas
and what
deberíamos
new
contar para
tools
su desarrollo.
we should have for this development.
Muchas gracias.
Thank you very much. Yes, this process of strategic litigation, we're all learning from constantly. The communities that are bringing cases, the judges, the mechanisms in themselves are developed little by little via litigation. Anaid, I have a question. In which ways does litigation, as we are stating today, in which way could that change in which we are considering the reparation of environmental damage? And we also know there's several cases and decisions made but not implemented. What are we missing? What do we need for this litigation to have more impact if we have any positive
Sí, claro.
decision?
Bueno, creo que también ya
Yes, of
parte de
course.
esta
I
pregunta se ha
think that
señalado en la
part of
conversación,
this
Natalia,
question we've
pero,
talked about
o sea, creo que es
what
muy
Natalia Nora has
importante
said, but I think
recalcar
it's
el hecho
important
que
to
el tipo de
highlight the
litigio
fact
que se
that the
plantea
type
desde
of
la
litigation
reparación del
that
daño,
is
reparación y
stated
restauración
from
del
reparation of damages
ecosistema, de la
and
naturaleza,
restoration of the ecosystem
pues
and
nos
nature,
hace ver
then
pasar
it
de este
makes us
litigio
see and go
tradicional
from
que
this
había y que
litigation
todavía existe, ¿no? De decir, bueno, a ver,
that
vamos a
still
señalar la
exists.
ilegalidad de un
So
proyecto
let's
tal vez,
see,
¿no? O sea, pasamos
let's
de
highlight
decir,
the illegality of a project. So we
conseguir
went
la
from
nulidad tal vez de una
finding
autorización, de un
a way
permiso,
of
de una
annulling an
licencia,
authorization,
y
a
los
permit, a
efectos de decir,
license,
bueno, pues
and
ya,
the
o sea, tu
purpose is
permiso no fue otorgado
okay,
conforme a la
or
ley.
the consequence is
O
okay, the law
en
didn't
otros
give you
casos,
this
otra
permit.
actividad
Or
ni
in some
siquiera es
cases, another
permitida, ¿no? Es
activity doesn't
ilegal,
have a permit
y
either,
entonces te
and
clausuramos, te
it's illegal.
cerramos,
So
impedimos que se siga llevando a
we
cabo,
hinder you from
pero quedaba, ¿no?
performing.
Justamente de
So,
lado,
but that was
pues, ¿qué pasa con el ecosistema,
from a
no?
side
O
of
sea, la
what
cuestión
happens
que
with the
señalaba Nora
ecosystem. The
sobre, bueno, si todo esto
anguish,
está muy bien, pero
Nora
¿el
was
ecosistema de
saying,
quién, no? O sea, podríamos
was
tener
talking about, but
personas
what happens with the
pensando, por ejemplo, en
ecosystem?
la
So yeah, we can have
responsabilidad
people
en
thinking
materia
about
penal, ¿no? Cuando
the
hablamos de
responsibility in criminal
delitos
matters when we talk
ambientales en
about
materia
environmental crimes
contra
in
la
terms of
biodiversidad, ¿no? Ok,
against
el
biodiversity.
agente, en el
Okay,
peor de
so
los
that
casos, se le puede dar
agent
su
in
libertad,
worst
¿no?
case
Y está en
scenario,
la cárcel,
they will
pero si
be
el medio ambiente,
incarcerated.
¿no?
But
Pasa
what
con la
about the
vida
environment?
silvestre, ¿qué pasa con la
What's
especie en
happening with
peligro,
the
etcétera,
wildlife?
etcétera?
What's happening
Entonces,
with the risks that are in
este
the
litigio
species
lo
that
que
are
nos
endangered? So
permite es desplazar ese
this
enfoque o
litigation
complementar ese enfoque que
displaces
puede haber
that
excluyentes y
approach
entonces
because this isn't
incorporar a la naturaleza y el medio
exclusive.
ambiente como
So
parte
incorporating
de,
this as part of
como víctima
the
incluso, ¿no? O sea, cuando hablamos
victims. In
nosotros de
fact, when
restauración,
we
cuando
talk
hablamos
about
de reparación,
restoration, when we talk about
hablamos del medio
reparation,
ambiente y de la
we talk
naturaleza
about the
como
environment
víctima
and
desde
nature
una
as
teoría
a
de
victim
derechos humanos. E incluso
from
entonces
the
nos
jargon
lleva
of
a un
human rights.
reconocimiento
And this takes us
indirecto
to have an
o
indirect
sutil de los derechos de
acknowledgement
la
or subtle
naturaleza, ¿no?
acknowledgement of
Entonces,
the rights that
que
nature
también es
has
algo
in
que hemos
itself,
avanzado
which is also
en Colombia,
advanced
pero bueno, en
in
México se va
Colombia,
avanzando
but in
también.
Mexico, we're moving
Entonces,
forward as well. So
cuando nosotros ponemos al centro esta
when
restauración, esta
we
reparación,
put
nos
this
obliga que
reparation
desde
and
la
restoration
estrategia
in the center, that
contenciosa
makes us from that contentious
y la
strategy
estrategia que se plantea de litigio,
so that
pues
we
también
see
sean
the litigation,
herramientas
and this will
para
have the
favorecer esta
argument,
restauración y esta reparación y llegar
and
incluso a la
this
ejecución de la
reparation
sentencia,
goes
¿no?
to
Que es
the
un gran reto
execution
que
of the
obviamente compartimos con Colombia. En
ruling, which
México
is a
tenemos
challenge we also
estas,
share with
estas
Colombia. In
sentencias
Mexico, we
que
have
vienen de la
these
Suprema Corte,
rulings,
donde
many of them from
además
the
del reto
Supreme
que
Court of
señalaba
Justice, where
Nora
the
con
challenge,
relación
as Nora
al
mentioned,
cambio en la
was
en
the
la
change
titularidad
of
de las personas
the
juzgadoras que forman parte del Poder
title
Judicial,
of those who judge.
pues también hay retos, por ejemplo,
There's
incluso
also
llegando a
challenges,
recursos
in
financieros,
fact,
¿no?
that
O sea,
go
cuando tú
from
te la
being
pasas
financial
demandando al
resources. So when
Estado
you're
y el Estado
suing the state
pierde,
constantly and the
al
state
final del día
loses,
restauración
at the end
también
of the day,
cuesta, ¿no? Te va a
restoration
costar algo,
also is expensive.
implica
It will
dinero.
cost and it implies
Entonces,
money. So
muchas veces, o
many
en la experiencia que
times
nosotros hemos
in the
tenido,
experience we've had,
una argumentación
an
que se toma,
argument
¿no? Es
that
decir, pues sí
we
queremos
take a
hacerlo,
lot
pero no
is,
tenemos
okay, we
dinero,
do want to do
¿no? O
this,
sea,
but we
esto
don't
nos va
have
a costar
money.
muchísimo, ¿de
This
dónde lo
will cost
sacamos?
a lot.
Y
Where do
entonces
we
eso
take
ha
it from?
ralentizado,
So that has
pues, ejecución de sentencias, ¿no?
slow
Esa es
down the
otra de las razones
executions.
también.
That's another of the
Además de los
reasons.
retos
And also
científicos
the
o de
challenge,
la ciencia
scientific
puede haber sobre
challenges
cómo
that we
determinamos
can
un
see
lugar
from science of how
accidentado
to determine
en
a
un río
baseline,
que ha sido
meaning in a
justamente
river that has
contaminado, por
been
ejemplo, por más buena
contaminated
gente,
for more than by more than one agent, as in it's happened in Mexico, what's the percentage of contribution to that pollution, and what will be my percentage of reparation? Because although I repair, and if my neighbor continues to contaminate, then how do I determine that baseline? So that's the type of questions we have for those who judge. So we have recognized that this transcends, and this will look into the legality of a project or an activity, and also from the demand, sending these arguments and routes that we could take, how to build the baseline without assuming the burden of proof, knowing that it can be reversed. So that's what we've seen. And I also believe that the agreement of Escazú, and I saw Jay's question about if we can request restoration of intermediate readings. I mean, I think you mean when the case is solved or until it's completely restored. And that takes me to talk about the Escazú agreement. In Article 8, which is mostly access to justice, and that's what has advanced the most, and it came to my attention. In Mexico, access to justice is what has advanced the most from the judicial form. Where we're lagging behind is, in my opinion, the right to participation. It's not information, it's participation. In Escazú agreement, Article 8, we saw that we can have cautionary measures. This takes us to talk about suspension. So you, as the one who judges it, while you decide if I'm right or not, then the work or permits are suspended. But the Escazú agreement goes beyond that. It talks about not only seizing damage, but mitigating. And it does talk about repairing damage as part of the precautionary measures within the time that the case is actually ended and there is a ruling. So just like in Colombia, we have that law that we have to meet, and we have this precedent in the court that has helped advance justice, at least in these rulings, without denying the challenge of implementation. In every country that we're working on, if there's a ruling, the implementation is always a barrier, but we have colleagues that are finding very creative ways, very practical ones, to contribute with the implementation, even in their lawsuits, creating very specific procedures with dates, activities in detail, and then asking judges for the implementation of the process, the scientific process presented, and also to secure implementation. But this is still a challenge. I have another question. Do you know of cases in Mexico where the environment that has been harmed has been restored by a non-state stakeholder? De facto, not 100%, but there have been cases where they tried to have actions against mining companies, for example, given a spill in the north area of the country, where the action led to an obligation of reparation, where there was a trust, and the economic part cannot be ignored. A trust which in theory would have to be useful for that reparation, for this body of water. The reality is that there were several problems from the beginning of the trust, and the community didn't necessarily participate of several of the rules and agreements to perform this reparation. So throughout years,
o sea, una vez más, por escrito, pues
And
está ahí
once
una
again,
obligación, un caso
there is an
pendiente, una
obligation
regla
in the
que no se
case that's
cumple,
written
que
down,
incluso
drafted,
se
but it
constituyó un
hasn't had
fideicomiso,
a good
que en muchos
ending.
otros
In fact, there was
casos
a
no se
trust
ha
that was
hecho, por ejemplo,
constituted, which
¿no?
has not been done in other
Pero
cases,
pues sigue la reparación ahí, sigue pendiente.
Y
but the
Gustavo, en
reparation
Colombia,
is still
algunos
pending.
casos donde ya ha habido restauración por
And
parte
in
de
Colombia, where
un
there
actor
has
no
been
estatal
restoration by a
que
non-state
podríamos tomar como ejemplo.
actor, is there any example we could see in that?
Bueno, sí, digamos, efectivamente ha habido,
Yes, in effect, there
que es
is
importante,
a
interesante,
case
que es el
that's
caso de Cerro
interesting,
Matoso.
the case of
Es
Cerro
un caso de una
Matoso.
empresa
It's a
minera.
case of a mining company.
Esta fue una empresa,
This is a
es un caso además
company
bien interesante y paradójico, porque aquí lo que dice
that's
básicamente la Corte
quite a
Constitucional
paradox, because what the
tutela,
Constitutional
frente a
Court
una
says
demanda interpuesta por una comunidad
in the writ
indígena,
of protection
es que el
set
hecho de
out
que
by
les
an
hayan
indigenous community, it said
otorgado,
the
de
fact
que
that they were
el titular
granted,
de la licencia
that
ambiental,
the
el titular
holder
de la
of the
licencia ambiental,
environmental license, which is a
estuviera
mining company,
incumpliendo,
was
perdón, cumpliendo con los términos y con
was
los
meeting
estándares de
the
emisiones
terms and
ambientales. Esa
standards of
licencia
atmospheric
ambiental
emissions
no
under the
supone que no
environmental
se hubiera
license. That
producido un
doesn't
daño
assume that there was
al
no
ambiente y
damage into the
específicamente como
environment,
daño
specifically
consecutivo, un daño a la
a
salud
consecutive
de la comunidad.
damage
Y
to
lo
the
que
health of the
efectivamente
members of
hace
the
la
community.
Corte es
And what
reconocer
the court
que
does
una
is
cosa es cumplir
acknowledge
con los
that one thing
estándares
is
o
to
con la
meet
norma
the
de emisiones
standards and the
atmosféricas que figure,
standard or
que está
regulation
avalada tanto
of
por la licencia como
atmospheric
por la regulación
emissions that
nacional.
has been
Y
set out
otra
by
cosa
national
es
regulation
que
and the
la
license. But it's a whole
contaminación
different topic
emitida
that
por la
because of
empresa
that
como razón
emitted
de la actividad
contamination,
minera, pues no se
given
hubiera
its mining
derivado
activity,
un daño
there is
para
no
el ambiente y un daño
byproduct, which was
consecutivo a la
the
salud de la
damage
comunidad. Y
for
se
the
ordenó
health of the
positivamente el
community.
resarcimiento.
And then they were ordered
Ese es un
to
fallo
repair.
que
That
efectivamente
is
se
one of the
considera
rulings that, in
incumplimiento
effect,
en
is
términos
in progress
del
in
es uno de
terms
los
of
fallos
compliance.
más
That is one of
interesantes
the most
que hay
interesting
precisamente
rulings
en términos
that
de
we've seen in
distinción entre el
terms
daño y
of
la contaminación.
distinction between the
Hace
damage
poco
and the
salió uno del Consejo de
contamination.
Estado que
Recently, there was
de
one
una
from
manera
the
muy
State
clara
Council
dice,
that goes against
no
it, actually,
necesariamente de la
not
contaminación se puede
necessarily in
inferir
terms
un
of
daño.
it was
Fue al
not
revés,
necessarily
no
contamination would bring
necesariamente
damage.
del
And
hecho de
this
que
was
no
the
haya
other way around. Not
contaminación no
necessarily the
permitida
fact that does
normativamente,
not, that we do
se
not
puede
show
indicar que
contamination,
exista un daño ambiental. Y le
that
atribuye a la
might not
empresa la
mean that
carga,
there
carga
is
de
no
diligencia
damage
de evidenciar si aún
in
estando
other
dentro de los
matters.
procedimientos
So we have to see
permitidos,
that even though we are in
se
under
produce o no
the
se produce un daño
permitted
efectivo al
limits,
ambiente,
there
un
could
daño
be deterioration
consecutivo a otros
in
derechos o
the
otros
environment or
beneficios
to other
tutelados
rights
como la
or
salud y a
legal
tomar las
rights
medidas
such as
pertinentes para el
health,
efecto.
and take measures for this purpose or because of this.
Tal vez nos da tiempo una última pregunta.
We have time for one last
Y,
question,
bueno, claro, nosotros nos estamos dedicando
and
este tiempo
we
a este
are
tema.
dedicated to this topic, of
Sabemos
course.
que deberíamos
We
tener
know that
derecho
we
de ver
should
a la
have
restauración y que
the
no puede ser
obligation to
el
reach
público que lo está
restoration,
pagando.
and it is not the
Tomando en
public
cuenta las
who is
oportunidades
paying
que
it right
se
now.
han presentado un poco hoy, pero
Considering the
también
opportunities we've seen today, but
los
also
impedimentos, las limitaciones, incluso
the
la implementación,
limitations, in fact,
es
in
que
the implementation,
analizo
and I
esta estrategia tiene
this
algún poder
strategy,
transformativo, por
does it
ejemplo, no
have a
sé, en
transformative
términos de
power?
cómo el
I don't know, in
público
terms
o el
of
gobierno
how
entiende el daño
the
y la
government
restauración,
understands the damage and restoration,
pero considerando también todos sus
considering also
limitantes,
all of the
¿es
limitations.
verdaderamente tiene algún potencial
Is
transformativo?
there truly a transformative potential?
Sí, absolutamente, porque, o sea, en realidad lo que seguimos
Absolutely,
haciendo,
yes. In
digamos, lo que
reality,
se
what we're
construye y yo
seeing
sigo construyendo, o sea,
and has been built,
o sea, es un poder transformador, pero también es incluso un poder de
there's a transformative
sobreprevención. Es decir,
project, but we need to
¿de qué nos
show the
sirve
evidence. So
tener una sanción
it
multimillonaria
is
que podamos
useless to
echar
have
a
a
los daños incluso
multi-billionaire
punitivos con
sanction
estas
and
sanciones
even punitive
exorbitantes,
sanctions
¿no? De
with the
miles de millones de dólares que
extraordinary
llevamos en Estados Unidos, si
fines,
al final del
let's say in the
día
US, if at the end of the
pues la
day,
naturaleza se sigue degradando y
nature is
dañando
still
con estas
degraded and
actividades que
deteriorated with
generan
these
el daño,
activities
¿no?
and the damage
Entonces,
continues.
concebir
So
estas acciones
conceiving
como
these
acciones no solo
actions
transformadoras
as
para la
actions that
sobrevivencia y
not
no solo la
only
sobrevivencia humana,
transforming, but
sino
about
también
survival, at human survival, and even the survival of the ecosystems, which at the end of the day allow our existence, then that takes us to talk about access to justice that truly responds to the actual needs and the dynamics that exist in nature, being us part of that nature as well. So our health depends on nature, our access to housing, the access to food, access to water, and how we build this chain of conditions that make our life be possible at the end of the day, and that finds an origin in nature. So this is transforming, but it's also vital. Having said that, in the case of Mexico, I think we should also talk about repair and reparation. This makes us recognize that there is a victim. When you do reparation, we think that who are those to be repaired? Who are the holders of that reparation? There's no victim, but in this case, it is nature, it's the environment, it's the river, it's the forest, etc., the mangroves. And that takes us to a conversation which I know that this is not the focus of today, but it's the rights of nature, because this opens a new path to access justice and access this reparation, which goes much more advanced in Colombia. But in Mexico, we're moving forward as well. And it's been recognized by the Inter-American Court last year, in fact, in a consultation number 32 on human rights. There's a specific section that connects the rights of nature with the climate crisis and how nature contributes to mitigate the effects of this crisis. So I think that transformative potential is something we have to take. And something I've noticed is that our legal systems in Latin America, we have a huge advantage, at least at the constitutional level. So we're talking permanently about, and we talk of human rights as a binding matter. So human rights allow for us access to justice, and it allows for us to talk about access to reparation, which does not happen in other countries. In other countries, they are just now starting to talk about acknowledging human rights. Do we or do we not? Although in public international law, we have the rapporteurs and procedures and United Nations, etc. But there's other countries that are lagging behind. They're just starting to ask themselves, okay, but what is the environment for us? Is it a human right? What is the environment? Is there human rights laws here in this country? And I'm not talking about those who we could think like the Middle East, but let's even Australia. I'm in Australia right now, and there's a conversation on whether there should be reforms to the legal system to recognize human rights. So imagine this in Latin America, going back, that transformative power of reparation with all of this legal scaffold and the progress we've made. This helps us at the end of the day to extend our survival. Thank you very much, Anaid, and very good point, because yes, the Colombian writ of protection, its tutela, the amparo in Mexico are unique when we talk about, and we're discussing with colleagues in other regions. They do not know about these different routes. They don't have them yet, at least. Gustavo, should we have the last word intervention by you? So what do you think about the transformative power? Could we have that? I did actually want to talk about this, and Anaid mentioned something very interesting. It's the recognition of nature as a victim. Colombia has been doing this. Colombia has done this, given the legal instance that's very powerful, created upon the peace accord, which is the special jurisdiction for peace, JEP or HEP. It has a temporary notion, which is to give justice and reparation versus all of the crimes that happened given the internal armed conflict. Well, this has given place to judicial rulings that have been innovative in acknowledging nature as a victim, nature's elements are
con una
victims as well. So the Cauca
sentencia
River, for
que
example,
todos
already has a
conocemos
ruling
como
under a writ of protection that is that acknowledges it
objeto
as
de
a
derechos.
subject of
Pues en
rights.
sede judicial de la JEP, la
In
Jurisdicción Especial
the
para la Paz, también
special
se
HEP court,
impulsaron medidas cautelares
there
y
were
decisiones
also precautionary measures
tendientes al
and
reconocimiento
rulings
de
that tended to
el río
acknowledge
como
the river
una
itself
víctima
as a
dentro del
victim
conflicto armado.
within the armed conflict.
Y ello, pues
And
por supuesto,
that
termina siendo
in
doblemente
itself
innovador,
ends up
porque
being
pues
a double
poner
innovation
a un
because
elemento de
it
la
is
naturaleza como,
acknowledging an element of
efectivamente,
nature
como
as
una
a
víctima o
victim
afectado con ocasión del
or
daño ambiental,
impacted
pero
by
además con ocasión
the
de un
environmental damage,
elemento
but
que
also
detona el
given an
daño
element
ambiental
that
como lo es el
detonates
conflicto armado.
environmental damage,
Y esto
such as the
termina
armed
siendo
conflict.
una
And
lección
that ends up
fundamental y
being a
relevante
key lesson that is very
en
relevant
materia de conflictos
in
también de
terms
carácter
of
internacional,
conflict
porque en
and
materia de procedimientos
international
internacionales
conflict, because in an
es
international
importante
conflict, this
establecer
ends up being important to
cuál
establish
es, digamos, el grado de nivel de
which
afectación
is
a la
the
base
degree
natural y
and
cómo se va a
impact
reparar y
into
cómo
our
resarcir
natural base, and how will
el
that be
base
repaired
natural que termina siendo afectada. Y
for
por ejemplo, cuando terminan
because
siendo
our natural
afectados
base is
valores
affected, and
que no
when there
necesariamente
are
son
also
ecológicos, sino que también
values
son
that are
valores
affected,
culturales, por
not only
ejemplo,
ecological but
afianzados
cultural,
o asociados a esos elementos de la
associated to
naturaleza.
those elements of nature.
Sucede en el caso del río
It
Atrato, sobre
happens
todo,
like
en el caso de la
in the case
sentencia
of
del
the
río
Atrato
Atrato,
River. In
pues
the
con
ruling
la famosa
for Rio Atrato that
presentación
Natalia
del
mentioned in her
informe,
presentation
se
and her
reconocieron no
report,
solamente los
they
derechos
recognize not
fundamentales del
only
río,
the
sino los derechos
fundamental rights of the river,
bioculturales
but the
y
biocultural
asociado entonces a
rights
todo
of the
la
river
biodiversidad,
associated to the
los derechos de las
biodiversity,
comunidades
the rights of
asentadas en
communities that
ese
have been
ecosistema
that have
y
settled in
cómo
that
era parte
ecosystem,
de su cultura
and
y parte
how
de
it
su,
was part of
de
their
su
culture
cosmovisión,
and their
de su forma de
cosmovision,
ser.
their
Entonces,
way of life.
creo que
So
aquí,
I think
y me
that,
sumo
and
a la
I
invitación que hace un rato hacía
connect to the
Ana
invitation that
Pérez,
Anaid
en el concepto de
gave us
las
today. We
prácticas
have to
innovadoras
be
tenemos
innovative
que
from
romper para los paradigmas
our jurisprudence.
con los que seguramente
We have to
fuimos
break
educados, ¿no?
paradigms
Yo
that
habitualmente
educated
en
us
clase
in
digo, por
the
ejemplo,
past.
el derecho de
I
propiedad que
say in class
conocemos
the
con el
law,
que
the
fuimos
property law that we knew, that
profesionalizados,
we
ya
were
no
trained
es el
in,
mismo derecho de
does
propiedad.
not exist any
De hecho,
longer.
tiene una doble condición y una doble naturaleza como derecho y como deber, incluso más profundizado como deber. Y yo creo que ese es buena
And
parte
I believe that that is a good part
del
of
aporte que tenemos que dar en
the
espacios como
contribution we have to have in spaces such as this one that we've seen today.
Muchas gracias. Gracias a Anaid,
Thank you very
Gustavo,
much. Thank you,
Natalia, Nora
Anaid,
y a
Gustavo,
Rose por su
Natalia, Nora, and Rose
interpretación y a
for
todos
her
ustedes por
interpretation,
participar.
and all of you for
Conservation
participating.
Litigation, nosotros
In
somos
conservation
colegas,
litigation,
amigos,
we are
súper
colleagues,
abiertos
friends,
a
very
compartir, a
much open
discutir.
to sharing,
Todos vamos
discussing,
aprendiendo poco a
and
poco
we're going to
juntos.
learn all
Lo que se ha
together,
discutido hoy, también buscando
little by
oportunidades,
little, and we are going to seek
actividades
opportunities
novedosas,
as well,
colaboraciones inusuales.
novel activities
Pronto les
and
estaremos
unusual
enviando los reportes que se han
collaborations. We will be
presentado
sending
hoy,
you the reports that we
enfocando
presented
las
today,
oportunidades en México, en
focusing
Colombia,
opportunities in Mexico
y les
and in
vamos
Colombia.
a
And we
invitar a
will
reflexionar sobre
invite
esos
you
reportes, sobre
to
la discusión de hoy,
think about these
con
reports and
puerta
the
abierta para
discussion
compartir
today.
sus
We are
sugerencias, ideas
open
para
to any
estratégicas,
suggestion,
estrategias,
any strategic
colaboraciones nuevas,
ideas,
casos
collaborations, new
específicos donde
strategies,
podríamos trabajar
specific case where
juntos.
we could work together.
Entonces, ya les
So
estaremos mandando esos
will be
reportes,
sending
tanto
you these
como
reports
detalles cómo se pueden comunicar con nosotros.
and details
Entonces,
on
gracias
how you can
nuevamente
communicate with us. So
a todos los que
thank
han
you very
participado
much
hoy
to all of
y
those who
espero
have
podamos estar en
participated today,
contacto
and
pronto.
hopefully we can
Muchas
be in
gracias y buen día.
contact in the future. Thank you very much and have a great day.
Muchas gracias a ustedes.
Gracias.
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 Gracias, feliz día a todos.